handed over in the morning for a minute if my lords can see.
Para 6.
Para 6 models. Well, this was 4-pager note. Note which was given. I'll just pass one more.
Well, the supplementary note.
Yes, we got please models. Para 6 model. On the second page. Start with by convention. Yes, may I please, Manoj? Just one aspect I would add to it, Malins. By convention, it has been established that the members of senior civil services, other serving or retired officers with the rank of a Secretary to Government of India, Chief Secretary of State Governments have been appointed as Election Commissioner, and the senior most election commissioners as Chief Election Commissioner on the basis of the database maintained by the DOPT. A list of serving and retired officers in the position of Secretary to Government of India, Chief Secretary in States is prepared. On this basis, a panel of name is then prepared. What is missing? One of the instructions are by Ministry of Law for consideration of the Prime Minister and President. The Prime Minister, after considering the panel of names, recommends one name to the President of India. A note with the recommendation is submitted to the President of India. This is the convention which is being followed. So there is a process of DOPT maintaining the list of different officers serving, and the DOPT maintains including their career track records. It is not that they only maintain that who's the senior in each ministry. So there is a lot of data being collected, and as I'm privy to, since I was arguing on reservation matter. So when they calculate, it's a very, very comprehensive data which is being maintained. Right today is to be identified in railway particular department, particular section, who has been appointed, his origin date of appointment, under which category, through the interview rules, through the promotion rules, which postings he have been. So all those details are being maintained. Once that list is prepared, based on that, the panel of name is given by Ministry of Law. And like any ministry, they have their own ways to look at it, which is being carried out. And based on that, the list goes to the Prime Minister with the note of recommendation.
Has there been any occasion when you have overlooked the senior most election commissioner in the matter of appointment of the chief election commissioner?
Because I can check that, but I mean, right now may not be positioned, but I can take this question and can.
We just wanted to know.
Yes, Manoj.
If you are given the right to supersede,
yes,
then you will have yes men. You'll be queuing up and they'll do whatever you wanted them to do, so that they get to the post and satisfy them. Completely erodes seniority. I mean, independence.
Well, that can be one way to certainly that there is a possibility.
You don't know how you do it.
Yes, Manoj. But
big system.
Well, then I think is going to be most important question would be. I mean, I'll certainly answer this one. I'm duty bound to answer this. But in each these cases, that how to what length this inquiry is to be made. We were on a convention that there's some convention which is being followed. There is some method which is there, and that method has got some basis to go because the DOPT being the highest authority which is maintaining the employment record of Government of India in different ministries, and that carries out and the panel goes to the respective ministry, which is Ministry of Law. There is some exercise carried out. The final panel name is given. So far as this is the process which is being carried out.
Yes.
I wanted to show that it appears that what is the current setup of the election commission in the country, because one aspect was raised that the need a separate secretariat. There is the independent secretariat, but currently this is available on their website also. So it's not I'm taking something from outside. That what is the current structure of the election commission?
May I just take a moment? Because the estimate on both sides is that it will continue to day 501.
May not. We have said maybe at least by half an hour we would like to devote to.
All right, very well. Then
we want to begin.
No, very well. No.
By 3:30.
No problem.
So, to your lordships, would like to continue tomorrow morning?
Of course, we will continue.
Tomorrow there will be some.
We'll be continuing. We will not be breaking up the constitution bit. After this is over, we'll stay up the Jallikattu.
Your lordship
is continuing the bench. No.
Grateful.
Tomorrow, There is another constitution bench, but that's the problem.
True. But then we will not break up this bench. That's all we are saying. Who wants to address this in
But
delegate?
in any case, we have to address Lord.
Well, in this matter, we would like to respond after Mr. Sharma and Mr.
That's right. We are going. Let's see how we will get. Yes.
Grateful.
Well, let's may kindly see the setup which has been explained.
Yes. But we just keep a time on this.
Well, I'll wrap up in 10 to 15 minutes.
Yes.
The commission has a separate secretariat at New Delhi consisting of about 300 officials in a hierarchical setup. 2 or 3 deputy election commissioner and the director general, who are the senior most officer in the secretariat, assist the commission. They are generally appointed from the national civil service of the country, are selected and appointed by the commission with tenure. Directors, principal secretaries, secretaries, under secretaries, and deputy secretaries support the deputy election commissioner and director general in turn. There is a functional and territorial distribution of work in the commission. The work is organized in division, branches, and sections. Each of the last mentioned unit is in charge of section officer. The main functional divisions are planning, judicial, administration, systematic voters education, and electoral participation.
Treat it as red, David.
Yes, so one can take it that.
We are just noting it, set up.
Yes, so there is a setup. Now, this setup linked with, if my lords can take the People Representation Act of 1950, 1950 People Representation Act.
1950 Act.
50 Act. The endeavor is to show how the statutory breakup of the administration of the entire exercise, going up to the last mile of declaration of result, and what is the involvement of the commission or the commissioner for that matter.
Just give us the sections.
Yes, I'll just give a.
So that, you know.
I'll just give those
You can
sections.
give a brief note if you don't know.
I'll certainly give that.
That will do. So we'll just notice as how the RP Act minimizes the importance of this is what you're trying to say.
Yes, the entire process is very, very independent. Different functionaries are allocated different jobs.
That's right.
Even this goes to the extent section 60 say, how do you declare result? No need of interference unless and until the election commissioner says that in absence of any direction.
So just give us those sections.
Well, I can
separate note. We'll make it give a note by. Well, we'll see.
I'll give the note on this what is the scheme under the People Representation Act so far as the independent functioning is concerned. Yes, yes. But the one judgment which my lords have seen numerous times, the MS give. Just one para of that I want to read.
Okay, paragraph.
Well, the last paragraph that is at. Well, my lords can take the compilation for a minute.
It just gives the drift of it. What is it? What is it?
Well, basically, there the request was made to the court that please make some guidelines so far as to build in the audiatum partum rule where there is a dispute in the candidature of someone. You frame those guidelines. How the court reacted to it, let's may kindly see that. Yes, this is page 1384 of this minute. I'm sorry.
Paragraph you have not given.
Well, I'll just give that. Page 1445, para 130.
Begin reading.
Yes, please. Being not altogether certain of all the facts and circumstances that may be made available in the appropriate forum, it may be a premature exercise by this court even to lay down guidelines when there is no hidebound formula of rules of natural justice to operate in all cases and at all times when a decision has to be made. Justice and fair play have often to be harmonized with the exigencies of situation in the light of accumulated totality of circumstances in a given case, having regard to the question of prejudice, not to the mere competent in an electoral contest, but to the real and larger issue of completion of free and fair election with the rigorous promptitude. Not being adequately informed of all facts and circumstances, this court will not make the task of election commissioner difficult and embarrassing by suggesting guidelines in a rather a twilight zone. Well, that's what I'm saying, that the court was very, very guarded, Malas, in this, in spite of, and interestingly, in this particular dispute, court said they should be heard. So even the on
That
the
was in which year? 1978.
yes, Malas, Malas, the
44 years ago.
December 2, 1977. Yes, Malas.
Yes, then.
Well, the one more, just one para in that, the 1986 4 SCC, page 78, para 15. There, the prayer was made that the appointment method of election commission be equated with the judges. Court said
Refused.
That's the, I think, Malazar, that was refused in that case.
That was refused. 86 or 96?
Well, this says 1986, 4 SCC, page 78, and para 15.
Yeah.
Well, as if I summarize what I wanted to point out was, but the first is my humble submission looking at the scheme which has been there right from 324, 324.5, respective law being made, people representation being there. This is a scheme in itself, even if looking at the Constitutional Assembly debate in terms of reading the mind of the constitution makers. There is no vacuum which today.
No vacuum.
Yes, that's the first submission I have, Malas. Second submission is that why subject to law has been put in 324.2, noting the background debate on that aspect, is that the freedom has been given to the parliament with the test of time. What is the time and what is the stage and what is the event should be the time when this should be exercised. Before that, the process which has been provided, if that process has got any error in terms of functionality of the commission, then this court is there to look into it and has been corrected on a numerous occasions. Therefore, this not is going to mandate to say that, well, if this argument would have come in 1960, assuming for a minute, and this would have been looked at from the point of view, say, no, you please frame a law in 1960, a law should have been framed. That could have been there, and today the situation. And with walk of life, I don't think the society is going to improve. The distrust and mistrust is going to increase by virtue of integration it has emerged in the society. So there can be a different features today we may not be even contemplate. And like in that privacy judgment, Justice Nariman said that so far as at the constitution making stage, the privacy would have been a very different meaning. Today, with the technological developments, it has completely gone into a different realm. Even terms of a location, geographical jurisdiction, nature, simple comment. So contemplating that these are the changing dimensions which will come, and underlying fact is that today there is no pointed fact which requires that some correction is there. No trigger point. That's the third thing which I want to point out. Fourth is that the test of Vineet Narayan or test of Vishaka which has been sent, two fundamental factors which are extremely important. One is there was a trigger. Second, there was a consensus where the union also was wanting that since there is a vacuum of any statute existing and not going to the umbrage of constitution to say that there is some method has been given. In that event, both the parties sat together. That may be IRC report or that may be Vishaka para 16 where it has been taken to note that we both agree that this is the area which is to be done. Third factor which is important in this case is those are the cases which are to be tested to the extent of violation of 21. So we are going to pitch, and those are the individual rights which are created. Today also one argument can be that somebody who's going to going to go vote, he has got a right to vote, and therefore there can be a breach if independence is not there. But when we look at those judgments, I think the fundamental point was that if there is a impact on an individual, life and liberty aspect comes into it, and or there is some grave failure, like CBI couldn't file in a charge sheet in time.
Tenuous.
Tenuous, yes, Malaj. That is the third thing which I want to point out, Malaj.
Tenuous.
Yes.
Then.
Fourth, Malaj, is the efficiency and independence is not in dispute today. And desirability can't be a test to step in, Malaj.
That's we have seen.
Last, Malaj, the reports have been a troubling point for my lords because my reports been saying, Malaj. There is a contradictory, in the same pages what we have read, Malaj. The simple example I am giving, they're saying the independent secretariat there, but the charge can be through vote. There's no need of a charge on a consolidated fund. It's fine. So those kind of are there. And most important answer, these kind of reports have been considered. One I pointed out in case of a judge's case, Malaj. And second is these reports are a constant endeavor to upgrade the administrative functioning of that.
Correct.
So whether those are to be treated as sacrosanct at every stage and necessarily to formulate it in law, in my respectful submission, may not be the right way to look at this. And the last being, Malaj, whom we are today doubting in absence of any action, are people with the administrative experience of 30 years. There is some check with the government which is maintaining, and we have not come across somebody who's been a fundamental charges have been leveled against any particular commissioner, in spite of that Ganguly and Tendulkar battle going on between them, which has come to a number of times. No, at no point seriously this has been pointed out saying that the a man of zero integrity has been taken up, and these are the charges against him, and therefore that's not a test even has been.
Is there any prohibition against them getting an assignment after they vacate the office of election commission or a chief election commissioner?
But there is no
No bar.
bar in that.
No bar.
There is
No
no bar.
cooling period.
There is also no cooling period also. There is no prohibition in that, and there is no cooling
bar
period.
and
Yes.
historically, have they been given subsequent assignments?
But I understand in one particular. No?
There's no assignment. After you deliver, there's no assignment.
All right, that's the more credible.
But if I'm not wrong,
No bar.
in civil services, there is a cooling period. Those who retire, and there is a cooling period of 1 year or 2 years.
1 year.
I think 1 year is there, cooling period is there.
Yes.
Under that. So this was not considered that. So this appointment as election commissioner is nothing to do with the cooling period there.
It's nothing to do.
So the day you retire, you can become an election commissioner. So where the cooling period comes in?
Pradeep, that's what I was trying to find out.
No, the cooling period is there.
Yes.
Now where it will apply, we don't know.
But the interesting part would
In
be
civil service, cooling period is there.
civil
But every
service.
2 years, it used to 1 year.
So would it be equated the constitutional to this? These are not that some advertisement is being given and it application. This is based on a judgment, which is based whatever factors are taken into it. So equating the constitutional appointments and equating the civil appointments will maybe a little different, where the rules and regulations are far more stringent to make the administration function and control. So broadly, in light of these submissions, my respectful submission is that there is the existing machinery which has worked well.
Thank you.
This may not be the stage, Maradhi. I'm so grateful.
I
for-
think the fundamental
What do you
point
want to
that
say?
you have,
What do you want to add? Everything has been said.
I'm sorry.
fundamental point that you are trying to raise is, brother, just one,
Sorry, go ahead.
is that these very machinery which is in place, the officers who have been selected, they have regularly conducted election all these years
Please.
without any, and the voting has also been to the extent that is expected.
Yes,
So therefore, there is no trigger point, that's
Yes.
the word.
that's right.
And the headaches that you have used the expression
Please.
are obviously something which can be taken care of on a case-to-case basis if there is a breach of fundamental.
I'm grateful. That's what I want to point. I'm grateful.
Yes, Mr. Mehta. You can say.
Well, I will not repeat anything, but
You're also appearing for Union of India only.
yes, for Union of India. But I am coming last, more logistically, not that.
Union of India, yes.
Yes, please. To answer the last question first. Whenever the Constitution has envisaged that a person who holds a particular office will not get any other assignment, as my lord rightly put, the Constitution has provided.
There is a bar.
And that is under Article 148 of the Constitution,
That's what-
Comptroller and Auditor General.
No such bar.
There is no such bar. Lord, what essentially, my Lord, we are debating on petitioner side, respondent sides, and troubling your lordship, what the constitutional provision should have been for an ideal appointment or an ideal process of selection of election commissioners, my Lord, which, in my respectful submission, may not be a subject matter of proceedings either under 32 or otherwise. If there are any lacunas, if at all, and I will point out there are none, it is for the legislature to fill in, not by an act of parliament, but by a constitutional amendment.
Here, Mr. Solicitor, the triggering thought for this is all these reports, law commission, etc., are somehow saying that it needs to be changed. So that is the,
Lord, that,
we call it a triggering thought.
correct, my Lord. But the triggering thought, my Lord, is always welcome. That necessarily, my
So
Lord,
whether it's a constitutional thought or not,
the law or anything develops because of such triggering thoughts. But the question is, which forum will make that change? No, that's essentially the argument we are making. My Lord, now kindly take the constitution, my Lord. For my satisfaction, I am not repeating, I am, my Lord, assisting your lordships in a different perspective. Kindly have, my Lord, 324.
Please, got it in our mind, yes.
No, my Lord, it's always, my Lord, a little satisfactory for a lawyer when your lordships have the bare act in hand, my Lord.
Yes.
Lord, your lordships may kindly come directly to 2. And the way, my Lord, in which, my Lord, the sub-article 2 is presented, I have a different perception to that. And your lordships may kindly consider that.
Yeah.
The election commission shall consist of the chief election commissioner and such number of other election commissioners, if any, as the president may from time to time fix, and the appointment of the chief election commissioner and other election commissioners shall. Now, Lord, mark this. Lord, this is the point which Lord, consumed your lordship's substantial time. Subject to the provisions of any law made in that behalf by Parliament, be made by the President. My Lord, the initial impression, my Lord, which one gets, and my Lord, it has been given to your lordship, is that President will be the appointing authority. How the appointment is to be made will be made by way of a law as contemplated under sub-article 2. My Lord, in my respectful submission, that is a wrong reading of sub-article 2. That's not the law which is contemplated, and I'll make that submission good. Subject, of course, to your lordship, meeting with your lordship's approval.
Yeah.
Kindly, my Lord, takes Article 53, which is the law which is being contemplated. And then I'll again read sub-article 2. Kindly takes Article 53.
53.
The powers of the president. The law which, my Lord, so far your lordships have been presented with, that there should be a law providing for a mechanism of his appointment. That's not the law which is contemplated. It's law under 53. My Lord, please have a look at 53. Article 53. Lord, it is under the chapter executive, the president and vice president. I'll directly go to 53. The executive power of the union shall be vested in the president and shall be exercised by him either directly or through officers subordinate to him in accordance with the constitution. Leave it, we are not concerned, not relevant. 2, we are not concerned, we are not relevant, I am skipping it, my Lord. Please, my Lord, now read, my Lord, with me sub-article 3. Nothing in this article shall, that is the power of the president. A, your lordships may ignore, come to B. Prevent the parliament from conferring by law functions on authorities other than the president. Meaning thereby, in exercise of the powers under Article 53, sub-article 3B, Parliament can say that this particular power of the president would not be exercised by the president, but would be exercised by some other body. Lord, I hope I am able to make myself clear. 53B is an enabling power conferred upon the legislature, namely the parliament, that it can, instead of president, invest the power upon someone else. Now, my lord, for my satisfaction, read 324B in this context.
So 1 minute, is it this sub-article B, does it encompass all the defined powers of president?
Yes, all powers of the president.
Assuming in the situation, president is the commander-in-chief of all the armed forces.
Yes, my lord.
Can parliament make a law today and say that, no, not the president, but some other
He is
authority?
saying correct, your lordships are right, my lord.
I agree with the question.
Yes,
That is right.
but it's very rude to say yes, correct, to a judge.
I'm not saying it.
Yes,
It's very rude to.
yes, my lord.
Can the commander-in-chief of the three forces?
I am reading, my lord, the way it is, my lord.
uh,
Nothing in this article, my lord, kindly see.
I mean, that's
It
what, so
cannot.
far as this litigation is concerned, that's possible.
No.
Academic, but this
The
one-
answer is no. The answer is in the article itself. Please read the article 1, sub-article 1. The executive power of the union shall vest in the president. So what can be delegated by way of a law is the executive power, not any other power. Executive power of the union shall be vested in the president and shall be exercised by him either directly or through officers subordinate to him in accordance with the constitution. Now that executive power,
that is an all-encompassing power.
not when he is the chief of the armed forces, he's not discharging
No, that's a
executive,
specific power,
the
yes.
specific power.
That's-
For example, power of granting pardon, etc. But here, my lord, all executive power, your lordship.
In Article 350.
Yes, my lord, all executive power is coterminous with the schedule. My lord, schedule 1 in list 1 in the 7 schedule. Lord, that is, my lord, now kindly read 324B 2.
Process is entered. See, 53(1) speaks about executive power.
Correct, my lord.
The executive power of the union government shall be vested with the president to be exercised by him. Now, sub-article 3, which you are referring to, it speaks about nothing in the article shall, which you wanted to read, prevent parliament from conferring by law functions. There's a distinction between powers and functions. The executive power of the union, in the case of, is the head of the, is a head. President is a ceremonial head, like the Queen or
Yes,
the King in England.
yes, my lord.
The executive power can be exercised only except in 2 or 3 well-established circumstances, only on the advice of the Council of Ministers. Now, how the Council of Ministers, who is to be consulted, it's laid down in under Article 77, read in the rules of business.
Correct, my lord.
Correct. So this may not have anything to do with it because we have no difficulty that the president's power has to be exercised.
I'm sorry.
Under 324B, on the basis of the Council of Ministers' advice.
So 324B neither uses the expression power nor function. It says the appointment shall be made by the president.
It's a power. It can only be a power.
That's how your lordships can read it, but it can be read even as a function of the president. And my lord, that may perhaps not make any logical difference so far as my lord 3B is concerned.
Yes.
It is that law which is contemplated that unless the power is conferred on someone else, the power will be exercised by the president. It's not, my lord, dependent upon a legislative power. And I tell your lordships the reason. What is the object? Now, there are certain functions.
While interpreting
Can
this
I-
provision, come out what you want to convey properly. Because we find it difficult. If you see 53 once again, and 1 and Article 3 subclause B again,
Yes, ma'am.
as pointed out to you, something is missing in between. Please see. 1 is exclusive power of the union vests with the president,
Correct, my lord.
or to whom he authorizes. Absolute, no discussion. If you come to 3, nothing is article shall be prevent parliament from conferring by law functions. As you've been told, executive power absolutely with the president. 3 only says functions on authorities other than the president. So if there is any other function which are delegated to authorities other than the president,
My lord,
this,
suppose,
by virtue of this clause, you can modulate and
take an example.
take away the power, the functions other than the president, vested with some other authorities.
Take an
But when the
example.
president is concerned, We don't think this B has any.
Look, take an example, my lord. Parliament in exercise of powers under Article 53 3B makes a law that the power or function, whichever nomenclature we may give, under Article 324 2 shall be exercised by a body consisting of A, B and C. That is permissible. But if that is not there, then the president will have the power to appoint.
That is what is specifically provided in 324B itself. The making of a law by Parliament is contemplated in 324B itself. You don't have to go to the 53B for that. Because also you will see nothing in this article.
Yes, my lord.
53B speaks about nothing in this article.
Correct, my lord. That is one. One, yes.
We are concerned with a separate chapter of the Constitution, which has a separate scheme. Even in the debates of the Constituent Assembly, initially the provisions relating to appointment of the Election Commission was contemplated as chapter to be included in the chapter on fundamental rights. They attached considerable importance to, so devoted a separate chapter to the Election Commission, dealt with in a standalone provision, then followed by 3-4 provisions which make up the whole chapter. The making of the law by Parliament, if you see the entire discussion, they had a lot of debate of what is going to happen if the president is going to be given the power. So they said somewhere down the line, they expected that, okay, if a situation arises, Parliament may step in. You can argue that, that period has not stepped in because you have got a very efficient setup. People are being appointed. Down the line, they are all very good people.
Yes.
So there is no trigger point. Parliament, it's a matter of wisdom. It's not a matter of
legality.
legality.
I'm obliged, Lord. I could not bring
And
my
again, understand
but
that there is a difference between power and function.
yes, Lord.
See, with respect to appointment, see, for example, the judges, the power is exercised for appointment.
Was
then,
used to be, my lord.
See, administering ought to the Chief Justice.
But used
It's
to
a
be.
function.
But used
It's not
to
the
be
power.
Used to
So
be
there is
exercised.
difference.
My lord, used to be exercised. I don't want to go into that, my lord, controversy, but
So there
our used to be
very
exercised.
carefully these words are used.
And my lord, it is during that exercise of power that we could, that system gave Justice Krishna Iyer and Justice H.R. Khanna. Thereafter, we made a better system, my lord. Recently, there was an article, my lord, yesterday or day before yesterday, where, my lord, some expression was used. I may not agree with Mr. Dushyant Dave in everything, but I agreed with that, my lord. But now, without using the expression which he has used, my lord, that this honorable court has usurped the power of the president. I don't use, my lord, I don't agree with that. Be that as it may, that's not the question, my lord, right now for your lordship's consideration. So your lordships are right, my lord. But, my lord, my respectful submission is, and I leave it at that because that's not a submission, my lord, in vain, submission in air. Your lordship's reading of Article 324B(2), that in absence of any power, how do you exercise the power? My respectful submission.
There is no difficulty.
I'm not, there is, nobody says, my lord, there is no power.
Nobody has a case that there is no power. Point is whether
Correct,
it's come to a stage where.
But, my lord, if there is no methodology of exercise of power prescribed as suggested by them, then, my lord, my respectful submission is that constitutional silence, as, my lord, a good word, my lord, fell from your lordships, cannot be filled in by way of a judicial interpretation. It can be done only and only by the Parliament.
Okay.
That's, my lord, the position. My lord, now, yesterday, my lord, during the discussion, my lord, there was some debate as to whether presence of someone who is, my lord, I would say non-executive person. My lord, your lordships are aware, my lord, the separation is very clear. Judiciary, executive and legislature. There is a theory of doctrine of the doctrine of separation of powers. But Lord, your lordships were pleased, my lord, just mull over it, my lord, as a my lord, loud thinking that maybe the presence of someone else might ensure, as my lord, going by the reports, that things are not messed up. Lord, there I have a serious problem, my lord, as an officer of the court, and please don't take this otherwise. This is my submission as a constitutional proposition, not individuals or institutions, as a constitutional proposition. Lord, constitution makers were very, very clear that some of the powers are vested upon executive and legislature, and some of the powers are vested only on the judiciary. The distinction was some of the powers the constitutional framers thought should be entrusted to the people's representatives chosen by the people who are answerable and accountable to the people every 5 years. That's why, my lord, this separation of powers. One organ will not entrench upon another organ. Second organ will not entrench upon the third organ. That's how, my lord, the balancing system in the constitution functions. Now, my lords, if your lordships were to consider that someone else, the presence of someone else might help the situation. What are the problems? Constitutional problems. I'm not on individuals or institutions for that matter.
Why you're asking someone else? We never proposed someone else.
No, there was a that for example, presence of the Chief Justice of India or some judge of the court, that fell as a.
There's only a kind of a deliberations going on.
No,
Someone else.
therefore,
We
I
never said someone else.
if that was deliberation only and not going to materialize in,
There's only deliberation going on.
Yeah.
Nothing can be. Someone else you have come.
then I have nothing more to add.
Someone else.
I have nothing more to add.
No, listen, yeah. According to someone else means whom?
My lord, I didn't want to name, but my lord, as suggested, that for example,
It's my submission. It's my submission which I've made.
That's correct.
I'll make it clear.
So make a submission.
then my lord, let me deal with it. Let me deal with it. His
That is from our
submission.
consumption.
No, absolutely. So I don't want Mr. Mehta to have the impression that we haven't made that. We have made that. I've made that submission.
I'm grateful to my learned friend. Lord, his submission is, let me put it this way, that there should be a presence of someone who is not a part of the executive. That's the submission, and I'm meeting with that submission.
Absolutely.
Did not fall from
That's
it.
also sufficient.
Yeah.
That's correct.
But now the problem is this. That would necessarily involve a process of rewriting the constitution. That's the first problem.
Correct.
Second, the moment this honorable court says that but for the presence of a non-executive, maybe my lord, from the judiciary, but not a part of the executive, the selection would not be proper, would depend upon true presuppositions, my lord, which your lordships will presume. A, it is not possible that the executive alone can discharge the functions constitutionally conferred upon it in absence of some outside presence, which negates the very concept of democracy, and democracy is in the preamble. It's a basic structure of the constitution. Executive consists of the people's chosen representatives. If one finds that one representative is wrongly chosen, that's his problem. Democracy works like that. Democracy works, my lord, he has selected one person to take all executive decisions, and your lordship's decision would not, in my respectful submission, be based upon a presumption that but for an outside presence, the executive will not be able to discharge its functions honestly or with transparency.
When you say that, historically, look at what happened in the CBI director's case.
I'll come to that.
Is not the CJI participating easy?
I'll come to that. I'll come to that, my lord.
So the democracy, when you talk about democracy, we don't want to say many things, but we just want to say that our court's history, our judgments, how our courts are approached, how the executive has accepted it also. There's no difficulty about it. CJIs do participate.
I'm not on individuals or institutions.
We are talking about.
I'm on constitutional proposition.
We are talking about. This is also part of democracy. The CBI director, vigilance commission. I think CVC.
CVC. Let me answer that.
So they're also.
Lord, they're the basic. Anything I can. It appears to be something very interesting though appears to be privileged communication, my lord.
No, it's just that, you know,
Sometimes, my lord, lighter moments are always.
like the moments we are discussing, I've got a very lengthy miscellaneous my list on Friday.
No, that's my lord. What the theory we used to, my lord, learn in first year of law, voluntary non-fit injury, my lord. Yeah, your lordships have taken that injury voluntarily, my lord, can't be helpful.
So you were saying about the
Yes, my lord.
CBI
Please,
director.
please, Lord, CBI director before Vinit Narayan judgment, Lord, was merely an officer of the government, not even a statutory functionary. Please, Lord, bear this distinction in mind. A mere officer, a statutory functionary, and a constitutional functionary.
Correct.
CBI director was a mere officer, was not even a statutory functionary, even till the law was subsequently amended. There was a vacuum as to how the person is to be selected. And the selection process by way of a constitutional mandate was not conferred upon the highest constitutional executive functionaries. Therefore, in absence of any, my lord, provision, your lordships, my lord, as a mere stopgap till the legislature steps in, because it was an unoccupied field, your lordships, my lord, said that. Lord, I would very earnestly urge, as a constitutional proposition, not to compare director CBI with a constitutional functionary, because, and my lord, I'm a word of caution, my lord, as an officer of the court. Similar provisions are made. Comptroller and Auditor General of India is elected in this under the same is selected or appointed under the same procedure.
The same procedure.
Governor is also appointed under the same procedure. Now, if the argument is to be accepted, Lord, would all constitutional functionaries be appointed by the executive necessarily with the help of someone from the judiciary?
You understand?
Lord, and my lord, I very earnestly and with profound respect, my lord, and as a constitutional proposition urge the theory of independence of judiciary and theory of independence of executive are equally sacrosanct under the constitution. That's a constitutional proposition. We cannot say that anything which interferes with the judicial organ of the state violates the independence of judiciary, but executive function can be interfered with, constitutionally speaking. It is equally sacrosanct.
Separation of powers.
Separation of powers, my lord. And therefore, my lord, I'll cite only few lines from some of the judgments, not the full judgments. It says the doctrine of separation of power stems from Article 14, equality. All three organs are equal in the eyes of the Constitution, and no one organ predominates the other.
It just straight away give those citations.
But my lord, I have, my lord, it is ready.
So we would like to.
My lord, I can't run against the time, my lord.
No, we want, because you know we have got a sort of time frame, and your points you have really very your characteristic way you have put across.
Yes, I do.
Which cannot be missed by anyone.
No, I wish, my lord,
they're going to think about it, ponder about it.
And my lord, sometimes, my lord, it may not. It's not a difficult.
We are not saying.
It's a difficult responsibility.
Very serious issue. We have to.
Lord, it's a difficult responsibility.
What will come of it is a different matter.
But Lord,
we are only saying we have to give it a very serious thought. What you are pointing out, very serious consequences it has.
I can read the.
That's all.
I'll not.
Yeah, we are saying that. We are saying that we are raised a very serious. We are not.
So, my lord, the first problem is that non-trusting the executive, that but for an outside interference, they would not be able to discharge the constitutional function, is constitutionally impermissible. And second, again, my lord, a very onerous responsibility to make this submission. But please take this as a constitutional proposition, not, my lord, otherwise. To, my lord, presuppose that it is only when there is a presence of one of the organs of the state, namely the judiciary, that transparency, accountability, and all other good things can be achieved, will also be constitutionally, my lord, not a correct position. Lord, we have bureaucrats. Bureaucrats are doing amazing work. They are deciding policies of the nation. They are deciding what are the nation's national policies with other countries. Lord, there may be inefficient bureaucrats, there may be inefficient politicians, there may be corrupt bureaucrats, there may be corrupt politicians. But this is the position in every sphere of life. So mere presence of someone from one organ can only ensure transparency, maybe a fallacious fundamental foundation to make an argument on, which my learned friend has sought to make. That is my second submission. Therefore, the Lordships may kindly not travel through that path which disturbs the constitutional balance of separation of powers. Because that might, we have to tread very, very carefully.
Absolutely.
And it might, why enter into an area which might have a...
Very delicate. What you said is right. It has to be done, whatever has to be done, it has to be done with a lot of care.
Yes, because I at the cost of repetition say the independence of executive within the bounds of the constitution is equally sacrosanct.
That's in Article 50 also.
Yes.
The directive principle.
Yes.
There can't be two opinions about it.
Yes.
Absolutely.
Absolutely.
What we put to them also and what I'm putting to you also, in 324(2), it says subject to the provisions of any law made in this behalf by the parliament, be made by the president. Our question is, where is that law as on today in place which permits you to proceed and process the names for appointment?
I bow down. I bow down. But that presupposes my 53B argument is not accepted for the time being. I presumed it and I go further. Because my first argument is that law is taking the conferring power on somebody else other than president. In absence of that law, the president will have the power. Look, suppose sub-article 2 is read as my lords have kind enough to say, and there is no law, then your lordships would make a suggestion to the parliament. There can't be a mandamus to the parliament, nor there can be an attempt to create, to fill up that constitutional silence by way of judicial interpretation. Because we are dealing with Constitution of India, not a statute.
Would this solicitor then suggest that the court should not undertake the exercise of saying what should be the process, but can certainly nudge the executive to do something which is expected to be done under
Yes,
324?
yes, that certainly your lordships can do. But that in absence of the law, this will be the law. Till you make the legislative enactment will not be, my lord, constitutionally permissible.
All right. All right.
Because we are dealing with a constitutional provision and not a statutory provision.
So we can now take from your statement that all appointments which are being made on the respective post of election commissioner or a chief election commissioner, they are randomly made on the basis of whatever the mechanism you consider to be appropriate. There is no law on the place.
Let me answer that, my lord. Let me answer.
So you said,
lauded question.
you said that we have not come out with any law with the law.
Lord, my answer is that, Lord, it's an enabling provision, not a mandatory provision.
You could have said that, all right,
It's a enabling
not mandatory, we have not followed it. Still, we have a mechanism in place, which is impartial and unbiased.
Kindly appreciate, my lord. It's an enabling provision. In absence of any law, it's not as if appointments cannot be made. No, my lord, this is something serious.
Yes.
Lord, the Constitution has conferred that power on the highest constitutional functionary, and he has his own way of appointing. My lord, I cannot, my lord, give an example. Otherwise, I would have given an example. My lord, all constitutional positions in all three organs of the state, including judiciary, there are no rules or there are no acts of appointment. Your lordships as a collegium do take into consideration intangible, my lord, facts which are not written down somewhere, that this would be the seniority, this would be the marks for judgment writing, mark for personality, mark for court behavior, etc. These are the intangible things. It is left to the wisdom of the people who are again constitutional functionaries. Here, President of India is the highest constitutional functionary.
You are not aware of. The attorney has given us a statement today, a written statement. And para 6 was read over to us. You have a copy?
I have, yes, I have read it.
It's something different. What you say is different than what is para 6 is different. Please read it. For clarification for us. You have it, this attorney, please have it.
I think
Let us have this para 6. Say, attorney, this was a supplementary submission on behalf of the Government of India.
Yes, a supplement, today's submission.
No, because today so many submissions were made. By convention. Yeah, this is para 6 says by convention it has been established.
Yes, yes, my lord, that's what I am saying.
You read it?
The Honorable President, I have read, my lord. The Honorable President has his own mechanism of selecting in absence of the law. But in absence of the law, which is not a mandate of the Constitution, neither the appointment would be illegal or can be termed as random, to say the least. These are all constitutional appointments made by the President of India, on whom power is vested by the Constitution.
You've understood, Solicitor. Nobody is suggesting that these appointments are illegal. And nobody has.
No, my lord, randomly made. Therefore, I must
What you're
answer.
saying is something different. What you're saying is, over a period of time from 1990 onwards, the government of India itself appointed committees, official reports, law commission reports, other committee reports.
Can be considered by the Parliament.
So that's a question. That's the only question.
Certainly, my lord, certainly. Now, my lord, I come to, my lord, some of the judgments, and, my lord, I conclude.
Yeah.
Lord, one more, my lord, just
give us, kindly give us those citations so that, and the paragraphs. Which you
no,
have-
no, I have quoted and highlighted. I'll read only highlighted part, not even quoted part.
Just, you don't have to read it. If you just give us a paragraph and we will.
Yes, madam.
No, let me, my lord, give me 5-10 minutes more.
We are telling you, we'll go through it. You don't, it's not as if we'll not go through
My
it.
lord, kindly, my lord, allow me for my satisfaction. Lord, kindly come to, first of all, page 16 of this, my lord. There is a new point.
Note, we'll see, we'll make a note of his written submission from Solicitor General. We'll go through each one of them.
Then I am not, my lord, going
We are
to,
bound to it, we'll do that.
Lord, page 16, my lord.
Yeah.
My lord, my point is,
Yeah.
the respectful submission is,
Judicial-
whenever,
You have raised judicial restraint, list.
no.
I mean, judicial
Your
restraint.
Lordship, may I-
legislation, something which-
I am sure your lordship's patience, my lord, I am fully assured of.
Yeah.
Page 16, my lord.
Yeah.
Bottom. Lord, the proposition is this.
Ah.
Whenever the Constitution has envisaged consultation by the President in exercise of his function or power, it has specifically provided for.
That's a good answer. Yes. That was not argued by anyone.
No, not, Lord, I am not repeating any of the
No,
submissions.
that's right.
Lord, please see 98.3, consultation with the head of respective legislative houses
Page 16.
while making rules of parliament. 124,
That's a new point. That's a new point.
consultation with the Chief Justice of India, or as it stood originally, etc., etc. Lord, I am not reading all.
Replicated.
Therefore, my lord, if your lordship reads any other presence or consultation, would be necessarily, Lord, in my respectful submission, rewriting the Constitution of India. Lord, now, your lordship, my lord, kindly come to page 11 only, my lord. And I'll just, my lord, I'll make your lordship's glance through it. That's all. I'll not read it. Only, my lord, allow me to read the highlighted part. Lord, page 2, Samsher Singh is the lead judgment on Article 53.
Yeah. Yes, yes.
Kindly, my lord, come to page 4, para 31. Lord, your lordship's question, how the appointments are made, but as per rules of business. That's how, my lord, it is answered. The president acts as per rules of business. So, in absence of a law, my lord, which the petitioner contend to be the law under sub-article 2, rules of business govern the field. And, my lord, that's how, my lord, the Constitution bench in Samsher Singh has held, my lord. Lord, I am not reading it. I assume, my lord, your lordships would definitely, my lord,
Go through
read.
each one of these.
Please read, my lord, Justice Krishna Iyer at page 6.
Yes.
Para 95, I'm not reading the entire thing.
Yes.
We are not unmindful of the agitational siege of parliamentary institutions and the anti-parliamentary build-up underway and the rashes of frustration showing up against the unsavory politics of power. But the limited task assigned to us is to interpret the Constitution as it is, not to venture starry-eyed proposals for reform. Even so, I'm sorry, Madam, I'm reading. Even so, our activism in interpretation must not be bogged down by logomachy or blinkered by legalism, but be aglow with insightful observations of Chief Justice Marshall. Then, my lord, 138 at the foot. The president in India is not at all a glorified cipher. He represents the majesty of the state. He is at the apex, though only symbolically, and has the rapport with the people and parties being above politics. His vigilant presence makes for good governance, if only if he uses what Bejhot described as the right to be consulted, to warn and encourage. Indeed, Article 78, Lord, then, my lord, it is Lord, very widely, my lord, that I'm just not to compare a power of President of India to appoint constitutional functionary with an officer like CBI director. That's not the purpose. Now, your lordships, my lord, I have cited TN session. Yes, my lord, your lordships may, my lord, kindly go through.
We'll go through.
Only two, my lord, paragraphs I'm tempted to say. My lord, because of the prayers made, my lord.
Yeah.
One is, my lord, State of Gujarat versus R.A. Mehta. Lord,
Governor,
Lokayukt's appointment, my lord. Where, my lord, very, my lord, succinctly, the Honorable Court has said, para 56.
56.
I give the citation, 2013, volume 3, SCC, page 1.
Is it part of this note?
No, it's not. Lord, therefore, Lord, I'll supply by tonight, by evening today.
Kindly repeat the citation once more.
I'll give that. Lord, 2013.
You're giving us a compilation.
Volume 3, SCC, page 1.
Yeah.
And, my lord, there are 5 judgments. All 5, my lord, I'll give. I rely upon, with para numbers, I'll give. I'm not reading it. I'm reading only 2 paras. The principle of checks and balances is a well-established philosophy in the governance of our country under our constitution. If we were all to have our way, each person would be allowed to wage a war against every other person. This reminds us to abide by the constitutional law, followed by the statutory law. Otherwise, everybody would sit in appeal against the judgment of everybody. In view of the aforesaid discussion, the law as evolved and applicable herein can be summarized to the effect that the governor is bound to act on the aid and advice of the Council of Ministers unless he acts as a persona designator under a particular statute, so and so. Lord, similar are the, Lord, propositions. And my last submission, Lord, Lord, what your lordships are called upon to decide or adjudicate or hold is a general sweeping law, that till the law comes into force, this will be the law, which in my respectful submission, not permissible. Any outside interference would violate the theory. Last, if any appointment is made, which is the appointment of an unqualified person or otherwise undesirable person, your lordship's power of judicial review remains.
See, there is nothing like unqualified person because you have not prescribed any qualifications.
Lord,
How do you say that there's
Lord, there was a case where
you understand what you're
I'm understanding.
Unfortunately, you have not put in place, like in Pakistan.
Wisely so.
Pakistan, they put in place.
But we don't follow Pakistan mostly.
We are not.
And that's the wise thing we do. Well, look at the position they have reached. And look at the position we have reached.
What is the neighborhood? They have said, for example, how do you define a senior bureaucrat? Somebody who has 20 years. You are following that as a convention, fine. But when you say it is a codification, it has to be prescribed.
I'm not saying that.
Cast in
Lord,
stone, you can
I
go
think,
for-
my lord, an unwarranted
You can say
use
suitable.
expression, my lord, is taken up. Lord, any appointment, if can be wanted to be challenged, can be challenged before your lordships.
On what ground?
In what it was, Lord, there
On
was,
what ground? On
Lord,
what
it
ground
was-
can be challenged?
Lord, it can be, Lord, it was challenged, and your lordships were pleased to set aside the person appointed was having, excuse me, sir, was having charge sheets against him. There is a judgment of your lordships, my lord. I'll just, my lord, this is one of the judgments, my lord, in this, my lord. That was an appointment of CVC, I think. But the Center for PIL, my learned friend, my lord, has, and the name of the person was P.J. Thomas. No, not, yes. So, my lord, I'm not saying that your lordship's power
Chief Secretary of Kerala.
is not available, but the power is not available at pre-appointment stage to decide the manner of appointment. The power is after the appointment is made, if there is some ground, but of course,
Thank you. Thank you.
these are the sufficient.
Thank you. Yes. Yes. Bhushan.
Just 10 minutes. I will not repeat anything, but just on few things. That
You give a note, otherwise we'll not get anywhere. Please give
I
your
leave
note.
it to my lord, but because
You can give your note.
the whole thing is debated for the election commission.
He's election commission. Should be.
Or you make it something, but strictly within 10 minutes.
Lord,
Just a moment, let us just, 10 minutes we want. Yes, go ahead.
Lords, at the foremost, Lords, I am not in the first matter, Lords. Election Commission of India is not a party, Lords, and rightly so, Lords. Because way appointment, Lords, we don't have a looker. So I am restricting it only to the second petition, which is Ashwini Kumar Upadhyay. In fact, my lords will see the prayers. It's a verbatim of all the reforms and proposals that we have sent to the Law Commission.
So you're supporting.
Replica of that, my lords.
You're
So
supporting.
what I'm trying to say is there's nothing new in that petition, my lords, from 1998 onwards till 2016, my lords. We had sent proposals after proposals, my lords, and it's my lord knows that the Law Commission has also proposed that we should have an independent secretariat, my lords. Also, my lords, insofar as the removability clause of the lords, insofar as election commissioners are concerned, my lords.
As they say, man proposes, God disposes.
So, my lords, my submission is, my lords, that should be looked seriously, my lords. Because today's time, my lords, when we go through the parliamentary debates and all, my lords, those times have changed now. And as rightly put forth by my lords, that now there cannot be a single manned commission. It's not possible practically today, my lords. So in fact, even in the constitutional debates, my lord, it has been debated. There were objections even with regard to the removability clause, although it was not taken up, my lords. And Dr. Ambedkar probably said that, we are running short of time. So that is the reason why it was not debated in so much of detail. But my lords, in today's time, when you say that you are co-equal, you exercise same powers, and if two of them, my lords, have taken a decision, they can take a decision, majority decision. Now, when you give so much of right, my lords, that you can actually decide an important issue on the basis of it.
What are you suggesting?
So, what I'm suggesting, my lords, that the same, my lords,
Same.
because it has to be by way of a constitutional amendment, my lords.
Exactly.
That's the point, my lords. We can't really go beyond that because the constitution very specifically says so, my lords. So I can't really go beyond that. But, my lord, it should be looked on, because we have made those proposals.
They should make an amendment to the constitution so that the election commissioner should be put on par with in regard to irremovability.
Absolutely, my
This
lords.
is what you want.
That is one point. Lords, as far as the, my lords,
And second, with respect to the commissionerate, the secretariat.
please, my lords. As far as the secretariat is concerned, my lords, now the commission works throughout the year, my lords.
So what is it that you want actually?
Because we want an independent secretariat.
Independent electorate.
Yes.
So what
Even
is
the budgetary allocation.
And it should be charged, budget should be expenditure should be a charged expenditure.
Absolutely.
Like the salary of the judges of the High Court,
Absolutely.
Supreme Court. So it should be. So what will that not involve the court foraying into a matter of policy, finances,
But
telling the government to make it
my lords,
consolidated?
so far as these issues are
And if
concerned,
they make it consolidated, they put say 1 lakh rupees or 2 lakh rupees.
no, my lords,
This is
when
salary of
you
your-
have a removability clause, my lords,
How do you
which is
tell them
compared.
what amount should be put? How do we tell them What amount should be put, well, that should be charged. Otherwise it's meaningless.
This can always come out from some kind of committee or consultation, my lords, which can look into it, my lords.
That's a
That's
that's
a
a
point, because
budget
we can ask them to
preparation.
look into it very
So that,
seriously
because-
and come out with
Because
something.
obviously, my lords, all the
Budget-
finances and economical issues have to be dealt with.
That's a budget.
We're not having enough, yes.
The law commission has proposed that. I can show that what.
That's
law
right,
commission-
that's right. Let us see.
Because, and because there was one.
They have all heard you, your submission. The complaint which you are making to us, they all have heard.
We have also put it
Attorney,
to them. We have
attorney
also-
and solicitor both have heard, but they're not.
Because it's on record, my lords.
And
It is
attorney then will
properly,
say
it's,
that
we have
it's
said
already
so in
the-
so many words in our counter affidavit.
You're putting them to shame, actually, that they're not able to.
Because there's nothing like that. Look, what,
Better we have a dialogue.
That's the beauty. That's the beauty of. That's the beauty.
because that in fact also shows that, Milord, I mean, I should not say that, Milord, but as an officer of the court, I can say that the projection is,
Why shouldn't you say what you wanted to say?
Milord, what I want, as an officer, I can say this, Milord, that the projection is that unless and until there is a mechanism, whoever is an incumbent is not doing his job.
Oh.
So, Milord, we've been working, Milord, I've been being a standing counsel.
Please repeat.
See our affidavit.
Please
So,
repeat your
as an
submission.
officer, I can say that, Milord.
Please repeat your.
What I say is, Milord, as an officer, Milord, that the impression which has been given from the petitioner's side, that till the time there is a mechanism at place,
For what? For appointment?
Milord, for appointment,
Ah.
the present election commission or in past, Milord, they have never worked.
Very good.
No, such a submission has not been made.
Milord, see, there was a,
In fact, no.
Milord,
You see, that's pointed out also. Such a submission, I mean, don't take it to that level. In fact, what is being suggested, and Mr. Balbir Singh has rightly said that we have conducted elections on time. We have had good people, number of voters participating. So therefore, the system that is in place is, you can't say that there are aberrations there.
there were some suggestions.
No, sorry. There's no complaint.
Don't go
made.
by that.
That's-
You don't have to answer that.
Yes.
way.
Came from my lords.
Oh,
that
sorry.
was a-
Nobody has said. Sorry, nobody has said.
Because the
They
second,
are completely silent on this issue. They never said that whatever the elections have been held in past so many terms, there is any kind of a aberration there. No, nobody has said.
Milords,
Only with respect
No,
to
no,
the
not-
strengthening
let
of,
me put
strengthening
it-
of
no,
independence.
but the strength of
Strengthening of
counsel,
independence,
because as
that
an
is
officer,
what
I
they
can
have.
say, Milords, it is strengthening, Milords.
Now what
No, no.
you said is not.
Let me put it this way.
Strengthening of
Just because we are
independence is
uttering the name of Sheshan every now and then, it doesn't mean that all the others have been,
No,
brushed with a
No, in
black
fact,
brush.
in fact,
Black
Milords, I
paint.
completely bow down when it fell from my lords that.
No,
he was
don't
the
go
person
by. Don't
from
dwell on-
Where it started.
Don't trouble yourself on that.
Milords, the second is, Milords, insofar as Milords, Milords, there was a question which fell from this court, Milords, about whether a right to vote is a constitutional right or a statutory right. Milords, I will just give the judgment, Milords, with paragraphs right, Kuldeep Nair,
What is your stand?
UCL.
What is your stand?
Milords, it is a statutory right, Milords.
It's not a constitutional right. Not a constitutional right.
Only insofar as a voter right to know about credentials, etc.
What do you say about 326?
Because 326, Milords, it doesn't give a right to a voter.
Why?
Because 326, I will.
Kindly read 326.
Yes, Milord.
Entitled. What is entitled?
Please read 326. I mean, you are the election commission. You should be telling us that they are.
Only for qualification.
No. We just read it. Very important that you read it.
Please, Milord.
What does it say?
Milords, election to the House of People
Yeah.
and to the legislative assemblies of state be on the basis of adult suffrage.
Please read on.
The elections to the House of People and to the legislative assembly of every state shall be on the basis of adult suffrage. That is to say, every person who is a citizen of India and who is not less than of age on such date as may be fixed in that behalf by or under any law made by appropriate legislature and is not otherwise disqualified under this constitution or any law made by the appropriate legislature on the ground of non-residence, unsoundness of mind, crime or corrupt or illegal practice shall be entitled to be registered as a voter.
So these are words which are, the lawyer knows, shall be entitled, 18 years, not disqualified. Now, if you are going to say that the parliament's power, when it sits in its legislative power, is going to override the constituent power, the constitution has contemplated giving the right. That is a fundamental thing. It was 21 years initially, lowered to 18 years.
That's right.
At the time of the constitution, that is what the debate is. That ancillary lawmaking by the legislature is contemplated for giving it actually teeth and flesh.
Yes.
Just because the disqualifications cannot be enlarged by the legislature. What are the disqualifications are mentioned in Article 326?
Please, my lords.
Can't be doing it. Now, if the legislature were to say, no, we will not do it, we will not make a law, certainly we would ban the Muslim. We'll say that you are defeating the constitutional right. I mean, fortunately, we don't have that position. But therefore, it may not be correct to say that Justice Chalamishra was not right. When he said there is a constitutional right, we have to, of course, how we have to modulate it, how do you state the law is a different thing.
Because
It has its
my lords,
underpinnings
I
in the
bow down, my lords,
Constitution.
but it has to be looked into from in a particular set of.
That's right. 2013 Tennessee page 1 proceeded to analyze four judgments. But the effect of 326, we'll have to see because this is a larger debt. We'll have to pronounce on it. All right. No, let them.
If your lordship is going to hear the Jellicut 2 at 3:30.
No, we like to conclude this first. We are not
So
going to.
let me then take
We have got time. We have
25 minutes.
I've handed up a spiral bound. I'll just quickly finish in about 20 minutes. Very good.
But I have prepared a brief written note and rejoinder
That's right.
where I have, of course, this is one of those unusual cases where 3 law officers have appeared for the union. That's why we had fairly exhaustive arguments, and of course, finally the Solicitor General with his usual weight of authority suggested that we now undo.
Where about that other matter?
Maybe not-
Tomorrow.
We will continue with Jellicut tomorrow.
Tomorrow morning, not so.
Certainly.
Yes, that's
So
right.
today seems
Today we don't know.
Today it won't finish.
if
We
you're
don't know how things will go.
one can wait, not one more early wait, but I don't know if it will be possible.
That's right.
So tomorrow.
Then I have to
Tomorrow,
wait.
10:30 tomorrow.
That will take tomorrow 100%.
No, not tomorrow. I'm here. I'll be here at 10:30.
We don't have to wait.
I'll be here.
Sorry for interruption.
I'll be here about 10:30. Sorry to interrupt you.
Fine.
Lord, I'll quickly run through
Yeah.
my submissions. So the Attorney General's submissions, my Lord, if I can summarize them, I have tried to summarize them here.
Yeah.
It says firstly that this court cannot issue directions to Parliament to enact a particular law in a particular manner. That was kind of supplemented or buttressed by or slight modification by the Solicitor General, who said that there is a separation of powers under the Constitution, and therefore this court can't even say or can't even tell the government or the president and say anything about how this power of appointments is to be exercised. Secondly, Lord, he said that the appointment of members of the Election Commission is in consonance with 324. Therefore, there is neither a vacuum nor the practice of appointment of members of the Election Commission can be said to be unconstitutional. He said there is no vacuum because government is appointing, government has been empowered, and so on. Then he says that merely because somebody aspires to have a better system doesn't mean that there is a vacuum. Then he says that there is no reason to think that the current system of appointment violates any fundamental rights under the Constitution. And then he says that the Law Commission report or the Dinesh Goswami Commission or the National Commission to Review the Constitution or the Administrative Reforms Commission have not suggested, have not discussed and suggested that the Election Commission is not neutral or that its lack of neutrality is because of this appointment being done by the government. Now, Lord, my response to all this is, firstly, we have not sought a mandamus to Parliament We are not asking Parliament, this court to direct Parliament to make any law. Therefore, this argument of separation of powers is inapplicable. We are praying for this court to exercise its powers under 32, read with 142 and 144 to issue a direction to the government to put in place an independent, rational, transparent system of selecting the members of the Election Commission till the framing of an appropriate legislation. Article 324 merely states that the appointment of the Chief Election Commissioner and other election commissioners shall be made by the President. There is no challenge to the power of the President to appoint election commissioners. The appointment has to be done by the President as it is done in the case of Supreme Court judges. Ultimately, the President issues the notification for appointment. However, the Constitution is silent on the selection and its process. In other words, the practice and procedure for selection is not defined. Further, there is no provision with respect to qualification for the members of the Election Commission. The government has also failed to produce any procedure that is followed by the executive, and therefore there is a vacuum, and this court can step in to issue guidelines on eligibility criteria, composition of the search committee, quorum of committees, and procedures that the committee must follow. Composition of the selection committee, Your Lordship may say, not the search committee, of the selection committee. Because it's...
Mr. Bhushan.
Yes. Yes.
Quite apart from the fact that this is a kind of a unique situation where we are trying to do all this in the context of a constitutional provision.
Yes.
Like an ordinary executive power, statutory power. This is the Constitution itself. We are being asked to make an invasion, as he calls it, transgressing on the boundaries, separating each organ from the other, number one. We'll get over that. Whatever way we have, we can do that. Perhaps. Other more important kind of judgment starting like this from 1984 to SEC relating to adoption, public investigation, court issuing direction like Union Carbide, Ahmedabad Chief Judicial Magistrate case, and finally the judge's case. And of course the CBI director case and the court issued guidelines. They were all premised on one singular circumstance, which is that in the absence of any law.
Yes.
So to begin with, there is a vacuum.
Yes.
Now, here the first question is whether there is a vacuum.
Yes.
Now, if there was a vacuum, it cannot explain how for the past 70 years we have had a long line of chief election commissioners for the first 40 years.
Yes.
Thereafter, from 1989 onwards.
Yes.
A short gap, and then from 93 onwards.
Yes.
We have had also a multi-member team.
Yes.
Being appointed. Now, is there a procedure for appointment? The president appoints means under a constitutional democracy as we have, Westminster model, Article 74, Article 77,
yes,
read with the rules of...
But I am answering all this.
No, what you're saying is,
yes,
not a case where there is a vacuum which is produced a corresponding infringement on a fundamental right, which again in turn is a question which we'll have to ask ourselves whether there is a fundamental right.
Yes.
Because you have to link all this together.
Yes, Lord. That's what I'm trying to answer.
Whether there is a vacuum.
Yes. So
also you missed out one important connection by the Solicitor General.
Yes.
Contented the belief that, or that is crept in, that only the presence of a judiciary will make matters transparent. That is impermissible. Constitutionally impermissible.
I have not.
Such a contention was.
I have not argued that only the presence of the judiciary. I have said that there needs to be a neutral and an independent body to select election commissioners. And the fact that there is no neutral or independent body may lead to and has led to selection of election commissioners who may not be and often have not been independent. I arguments delve into the question as to why there is reason. Now, this trigger point argument, if there has been no trigger point, etc., in the petition of the Association for Democratic Reforms, which was filed in 2021, my lord, we have not only annexed the report of the Citizens Committee, which details at great length at least 50 instances of the Election Commission not behaving independently. I didn't want to go into that because I thought it was not necessary for me to go into that. The reports, why are the Law Commission, Goswami Commission, it is said, it was argued by the Attorney General that look, they have not gone into this matter at great length. They have not first said that the Election Commission is not behaving independently, therefore we need to put in place an independent mechanism. Or that in the absence of an independent mechanism, Election Commission will not be independent. Of course, the Citizens Committee has said so explicitly. They have said so explicitly, repeatedly. Here are the instances of the Election Commission not behaving independently. And this is why they do not behave independently, because the appointments are completely. Of course, they recognize that the Election Commission has functional independence in the sense that the government has no disciplinary power over them. But they say that it is happening because the government has complete and unilateral control over the method of appointment, and the partisan behavior of the Election Commission is writ large to see. And therefore, my lord, for us to believe that Law Commission, Administrative Reforms Commission, Goswami Commission, National Commission to review the working of all of them would make this recommendation in the air, in the absence of their not realizing or feeling on the basis of the evidence that was before them that look, Election Commission's independence is questionable if the appointments continue to remain unilaterally in the hands of the government. As my lord, somebody said that though it is good to keep our minds open, but not so open that our brains fall out. So, I mean, one can go on saying that, look, there is no trigger point, there is no reason to believe why the Election Commission will not behave independently. There is no material to suggest that the Election Commission has. I could go into that. I could spend a lot of your lordship's time. Citizens Commission has gone, Citizens Committee has gone into it, headed by Justice Lokur at great length, pointed out large number of instances. But I thought that it was not necessary to get into that because there is judicial recognition of the fact in the judge's appointment case. Judge's appointment case also, the court did not go into the material to show why the appointment by the government alone or the selection of judges by the government alone is leading to non-independent judges. They said it's given. They said this is axiomatic, that if the selection remains in the hands of the government, it will lead to a great danger to the independence of the judiciary because it will lead to selection of not independent judges.
There are two questions here.
Yes.
We'll have to both Gopal, will also listen and they can answer. One of the contention was that if the Chief Justice is made a party,
Yes.
is a member of the collegium, also
Yes.
called collegium.
Yes.
Now, you can't, you also agree that the president will continue to be the person who will issue the order of appointment?
Yes, of course.
Now, under the constitution, president means the council of ministers. Now, a three-member collegium, as we put it, the prime minister, leader of the opposition, and let's say the chief justice, as recommended by the. What will be their exact role? Will their role be that they have a panel and they recommend somebody? Then what is the role of the council of ministers? Unless we say that the council of ministers is to be eclipsed completely, in which case it will actually incur the wrath of Article 74 and the whole core of the constitution being based on, council of ministers advising the president. A third party like a collegium, which you are suggesting.
But that is.
We are concerned with that.
Yes, I understand.
That is because we can't reduce our chief justice. to be somebody who goes there and makes a recommendation which at the hands of the Council of Ministers will die a premature death. If the Chief Justice goes in keeping with the prestige of the office of the Chief Justice, it should carry enough weight that it should finally mature into an order of appointment being issued by the President. Otherwise, we'll be lowering
No, that's
dignity
true.
of our President.
That's the order. The order of appointment is also made by the president.
There's no constitution. There's not a provision as
That is relevant. I respect that.
what has to do with the Council of Ministers. You tell us what is to be done with the Council. Does it
Yes.
have to, under the
Yes, yes.
rules of business, do we then say, supposing this is a matter, see, there are matters under the rules of
Yeah.
the entire cabinet.
Yes.
There are matters which go only to a particular minister.
This one goes only to the prime minister.
It goes only to the Prime Minister.
Now,
You say this-
yeah, they've said so. They've said so, that it goes only to the prime minister. But what I am saying is, once your lordship lays down that in order to ensure the neutrality and independence of the election commission, which is essential for free and fair elections, which is part of the basic structure of the constitution, which is part of the constitution and indeed part of the basic structure of the constitution, then the selection of the election commissioners cannot be merely in the hands of the government.
There,
And
we
to
are-
the
there
extent,
we would like to ask you one more question.
yes,
About those two, which will really go substantially.
yes,
Question at that. You want somebody to be appointed who will turn out to be the best man, the most independent man,
yes,
man of integrity.
yes,
Now, let us say that we accept your proposal. We
Yes.
say the Chief Justice will also be a part.
Chief Justice and the leader of opposition, like,
They will look it up.
yes,
Now, unless we also go ahead and say,
yes.
what are the qualifications? Who will make it to the panel? Will there be a panel of, what will be the number of persons who will be considered?
So,
The executive will prepare a panel. And if the Chief Justice goes there, it might be a one-day affair, a half an hour affair. He goes through the papers. We say, okay, the ACR of all these civil servants, they are outstanding. All are outstanding. So from out of them, how do you select them? Okay, seniority is one criteria. Pick the name of that man. There's nothing against him.
so my respectful
What
submission,
we are saying is that whether on the ground this is going to produce results.
Yes, my lord,
what we are
I-
really concerned with.
I agree, and that's why, my lord, I have said, I have pointed out that in the case of the Information Commission, this court has laid down several safeguards. One is, they have said that, of course, the Act says there is a qualification criteria under the CVC Act and under the Information Commission Act, RTI Act. And there the qualifications are mentioned, all kinds of people, not merely civil servants. And in fact, this court remarked that you have been choosing only civil servants. When there are so many other categories of people who can be appointed, who are eligible to be appointed, why don't you consider those? Why don't you ask for applications? And now they have started asking for applications, and about 500 and so applications come. And from that, my lord, there is a search committee which was also directed by the court. The search committee makes a short list. That short list made by the search committee and the criteria prepared by the search committee is supposed to be put out on a website. That's the transparency. I have mentioned all that. If your lordship just comes,
We'll go through that. See whether
we've given,
you're commenting that. So
Even-
our fundamental issue is going to be finally whether there is a vacuum.
yes. So there is
Without
a vacuum.
How do we step in?
Yes, my lord, the vacuum can be seen in many ways. One is when Parliament was supposed to make a law to provide for the procedure, etc., and no law has been made, obviously there is a vacuum.
So if that is so, there are many provisions in the Constitution
Yes,
which contemplates making of a law by Parliament.
yes.
In all these cases, will this become a precedent
No,
on the basis of which we can come to court, everybody can
no,
come to
no,
court?
no, not in all these cases. So That's related to the trigger. I say that there is trigger in the reports of these 5 bodies. Same thing happened in the police reforms case. In the Police Act, the appointment was made by the president of the DGP, etc. But this court said that, look, there are these 4 reports, starting with the Dharamvira committee, etc., which have been saying that, look, you need to make the police somewhat independent of the government in order to enforce the rule of law, because otherwise they act as instruments of the political executive. And therefore, in order to protect the rule of law, which is part of the basic structure of the Constitution, therefore we have to now make the following directions for police reforms, and they made fairly comprehensive 6 directions. Not merely the appointment of the DGP, they also said appointment of the DGP shall be in this manner, that the Public Service Commission will prepare a panel of 3 names on this basis, and among those 3 names, the government can select one. So they made various directions about police complaints authorities, about police establishment boards, National Security Commission.
Police acts have been made. Police acts have been made subsequently or amended.
Yes, some of those acts, my lord, have been stayed by this court by pointing out that they are inconsistent with the basis on which these directions were issued.
Can we equate that with the appointment of a constitutional authority?
In my respectful submission,
Is it not different?
in my respectful submission, my lord, that is not
Whether it should
different.
be viewed differently?
In my respectful submission, there is no difference because.
We are only asking.
Yes, my lord. In my respectful submission, if there is a vacuum in the Constitution itself, suppose, my lord, the word subject to a law made by Parliament was not there. Suppose that was not there, original act was there. Dr. Ambedkar introduced that subject thinking that Parliament will make a law to provide for the procedure, etc. Unfortunately, that has not happened. One way of looking at the vacuum is that it is a vacuum created by the non-making of any law by Parliament. The other way of looking at the vacuum is, suppose this word was not there, subject to any law made by Parliament, and the original Constitution just said that the Election Commission shall be appointed by the President. Even then, in my respectful submission, there would be a vacuum, because mere fact that the election commissioner will be appointed by the president does not mean that the executive will not lay down a procedure for the selection of these election commissioners. Even then, there would be a gap in the Constitution. It would be a gap which can be directed to be filled.
Okay.
If that gap has the consequence of violating either fundamental rights or violating or leading to the violation of any basic feature of the Constitution, etc. And I respectfully submit that in this case, all those elements are there.
Okay.
And we are being asked today by the Solicitor General to put the clock back and for the court to say, no, this untrammeled power has been given to the executive. And therefore, if the court makes any directions regarding this, then it will violate the principle of separation of powers. Lord, this bridge we have crossed long time back. From Vishaka onwards, we have crossed it long time back. And this court has repeatedly said there are any number of cases now that that proposition, that kind of broad proposition is not correct. Then, my lord, para 5 of this, it is pertinent to mention that there is a distinction between the word selection and appointment in service jurisprudence. When the framers of the Constitution have used the word appointment in 324(2), then it is not possible to read the word selection in its place. In other words, the word appointment cannot be read to include the word selection. The article merely says appointment, that is actual act of posting a person to a particular office, is to be done by the president and not the selection. Therefore, there exists a vacuum. So what I'm saying is that the act of selection is different from the act of appointment. And therefore, about selection, the Constitution says nothing. It only leaves it to a law made by Parliament, which has not been made about selection, how the person will be selected, what would be the process, who would be in the selection committee, etc. That all could have been laid down, should have been laid down by a law. Therefore, there is a vacuum. And trigger, my lord, as I have said, trigger is clearly there. It's not the case that when four committees, four such eminent bodies say this, obviously there is a problem. And after that, the Citizen Commission also. There have been, then, my lord, then para 7. This Honorable Court on various occasions has issued directions or guidelines for the purpose of protecting fundamental rights or preserving the rule of law, and such guidelines or directions have been given effect of law by the Parliament through a not just law.
Yes.
In the whistleblower protection case, my lord, this is what the resolution itself says. 2004, the resolution came, which put in place an administrative mechanism for whistleblower protection and made the CBC the nodal authority. And it says that the preamble of the notification reads, whereas while hearing writ petition number so-and-so regarding the murder of Sri Satyendra Dubey, Supreme Court desired that pending enactment of a suitable legislation, suitable machinery should be put in place for acting on complaints from whistleblowers.
Which is that citation?
That's in the whistleblower notification. We'll hand over the notification.
You hand over the notification?
Yes, I'll hand over the
notification. Put it down in writing, what else you have to say.
It's the
what else you have to say, you can put it down in writing so that...
No, I have put it down in writing. I just wanted to, my lord, emphasize a few things that in all these cases, after the directions of the court, whether it's the whistleblower case or the sexual...
They come out with laws.
No, first they came about with administrative notifications, putting in place a mechanism. The laws came sometimes 10, 12 years later. First, the government, because the court said that till the time that there is any law, these directions will hold the field. So they had to come out with a notification.
Correct.
So therefore, my lord, in all these cases, this happened. And even in the street vendors case, it was this court which said that, look, street vendors have some rights. You can't deal with street vendors like this. And that's why eventually that Street Vendors Act came. They have some fundamental rights. A system where there is no procedure or qualification laid down for the purpose of selection is incompatible with Article 14 of the Constitution.
You kindly give us a note for whatever you have to.
Yes, Lord. I have handed over this.
That we will go through it.
All right.
Yes,
and I just wanted to point out that this latest appointment of Mr. Arun Goel, this has been made by giving him voluntary retirement. Thursday, your lordship heard the argument. Friday, he was a secretary in the government, sitting secretary. Otherwise, my lord, all the people, virtually everybody who has been appointed were retired people. He was a sitting secretary, given voluntary retirement on Friday. And his appointment order apparently is issued on Saturday or Sunday. And he starts working from Monday. So, Thursday, your lordship heard this case where I mentioned that there is one vacancy and I'm seeking interim orders in this case. So, what process, what procedure? In one day, you rush through his voluntary VRS, you give him VRS in one day.
See, VRS can be usually given only after 3-month notice.
Yes.
Under the rules, he must have given a 3-month notice.
I doubt it. I doubt
Unless they waive it. I don't know whether they can waive it.
I doubt it very much.
Normally, they have to give a 3-month notice.
That's why I'm saying that your lordship should ask for the records of this appointment.
Well,
I don't think this is a matter in which law to enter into contest the larger proposition. I said from May onwards, this matter is lying
We would like to
how do we juxtapose this in the court? I mean, I'm strongly opposing this.
Sorry, Attorney General, we would like to ask you this.
Yes.
We heard this case on a Thursday. Last Thursday, we began hearing this case, and then Friday we had a miscellaneous. Last Thursday.
Let me put it like this.
No, we'd like to know.
Yeah.
Thursday we began hearing. At that stage, Mr. Bhushan said, we have an interim application. This is an urgent matter. Then in the interim, then the next hearing takes place yesterday. I mean, it took place yesterday. We began yesterday, on Tuesday.
I would only venture to say there is no design. I'd only venture to say.
We are not saying that.
That's
So therefore, we would like you
I
to produce the files relating to the appointment of this officer, so that if you are in the right, as you claim to be, that there is no hanky-panky, you have nothing to fear. Do you have any hesitation in producing the file?
The question is, no,
Therefore, I think we
talk on the field. He may have more information than me.
No, I am
Right,
speaking
because-
from the newspaper articles.
Therefore, right information travels to such a length. You may have more
Either the
information
commission,
than me.
election
But the
commission,
question,
lawyer was it a case where was he appointed on the basis of voluntary retirement? Was he an officer in service? What was the mechanism by which he was picked up Attorney General?
We
And
know-
it's being made when the matter is being considered by us.
We are the,
That's right.
let me
That's
be
why we are
different.
hearing the matter.
Only information I had was.
See, when there is an
Since
application,
May-
when there is an application against this appointment, about the appointment of any member pending, and that the matter is being heard by the
No,
Constitution.
This,
We thought
even-
that
even
we are
if I-
saying that, it could have been more appropriate. at times.
I don't want to resist
Say
any,
that we are
I don't want to
doing it.
resist any matter being seen.
That's right.
But to pick up a flag, an issue like this and say, look here, I am bringing before you a matter of concern how there is an attempt to,
You could have.
that's,
you could
I have strong
you could have-
reservations with
When
that.
an application is filed by a party and it is pending before us, and we have begun hearing of the matter.
But that was it,
why
was it an injunction?
Through?
No, was it an injunction as say that not make any appointments in the meanwhile to the
There
election?
was no such order.
That's right. Therefore, there
But
was
then
no
you could have-
injunction.
But then the application is there.
Uh,
But anyway, let that go. Let that go.
That is
We
true.
are not going to, we
I mean,
are not
then
taking judgment over that appointment. But we would like to know, because this would be an eye-opener, because you are claiming that everything is hunky-dory. Everything is going on very smoothly, efficiently, the most competent men of integrity.
Yeah,
and
it's-
innocent. You have nothing to fear.
I would not like to
We
venture
would
to
like to-
answer on a.
Don't answer.
I would not like to. I think it's improper on my
Yeah,
part.
we
My learned friend can say anything because as I said, look here,
that's right.
just
but
before it took a voluntary retirement,
Please
that's
listen
what
to-
it means a voluntary retirement. I'm sorry.
We are only asking you to just make available the file unless you have a legitimate objection to our asking you to do that, in which case we'll withdraw the order. We would only like you to, we are only asking you because the file will be there. From the file we
I mean,
know how it is done.
why would attorneys try to keep any information from the court? Certainly.
So please.
But I would like to first satisfy myself.
Just for our satisfaction.
I would like to
We
satisfy
would like to
myself that,
see that file.
yeah.
Unless you say that you would not want to, you would have some claim
Yeah.
of privilege or something under which you will want to.
Let you put it like this. Well, I don't think we need to travel
By
that
saying
length.
that, by saying that, it will be maybe to your advantage, because then you will be able to say there is a procedure followed.
No, I quite see.
Get to see.
I
Not that we are
only a small
You
response.
can't possibly sit on in judgment over the appointment. That is not challenged before us.
Certainly.
But
I-
we are for the purpose of generally understanding how things take place.
This is like a drawing a red herring so that you have I don't think that should.
So we would like to have that. That's a different matter. No?
Let me first satisfy myself, and then if there is something to be disclosed to the court, shared with the court, certainly it's my responsibility. But to say that there is an attempt.
How will you know how will we be satisfied?
No, I wanted to say this, that if I am, of course, that need to be shown to the court. I certainly should.
This is a matter, we are saying this because this order of appointment was made after we began hearing the matter, when there is an application saying, don't make the appointment. Is that an application?
Yes,
No.
yes.
That application is made, so we get session over it. Unless you wish to refuse to disclose it, in which case we don't think the way we know you, that it's not that adversarial. We are only asking you. We just like our curiosity is intertwined with our beauty. Otherwise, we have no,
I don't think I.
Attorney, if I may just, Attorney General. It may not be a case of, let us say, overreaching, but overreading the mind of the court.
Whether the lines may be very thinly drawn, my lords. The language only. But I
Just
only reaction.
only saying this the circumstances about this.
Can I not make this request to the court? We are in the realm of a larger question.
That's right. That is interlinked.
Now, the interlink
Interlink
is sought to be brought in to show, throw doubts, to look at you must necessarily get into the larger question.
You tell us.
I have some reservations about that.
That's right.
Because this solitary instance, you rely upon a 2019 citizens report, etc. And therefore, there's a trigger point. This trigger point is now, therefore, look at it. I have some reservations.
You have the file with you tomorrow.
Yes. Yes.
Because anyway, the way it is going, 10 minutes, I don't know, Shankaran will we may have to give some more time to them. So you have the file with you tomorrow, at least with you. And if you feel that you should not disclose to us, you will not.
No. Don't take it. Please don't take
You
it.
have the file with you. That's what we are saying.
The only,
let him proceed to the matter. We are not.
See, tomorrow I am before a different
You
constitution.
can have anyone who will have the file with him. That's all. We only want.
It may take a.
We don't think it is a matter where we should be withholding information. We are living in an open desk. And this is not a matter leading the point where a military person.
I don't want to give an impression that there is.
And from the court.
It is from the court.
I don't want to give an impression.
I'm not
all right.
asking to see
all
the
right.
facts.
I know how to handle my work. I don't have to get guidelines.
So you can just keep it with you. We are not.
The only difficulty is tomorrow I'm before the different constitution. Which I'm able to
be here.
Yes, I'm trying to steal some time and find out how it. I'm trying to work out how it can be done. But I have a serious reservation on.
All right.
So, my Lord, in the Citizens Report at page 5 of this, I have said that the Citizens Commission, they have mentioned many instances. I have only quoted a few of the actions of the Election Commission which throw doubt about its impartiality.
We are not rising. They just.
I'm sorry, sir.
And that's, Your Lordship may just note the page number of the
That's
compilation, 999. This quotation, which is at page 5 and 6.
In your note, you are giving it.
I have not written the page.
That's all right.
I've given the note.
So we'll go through this.
No, but the page number, Your Lordship.
We have seen.
999.
Yes.
Then the report mentions the reason why this is happening. They say one of the major reasons for the alleged kowtowing of the ECI before the political executive in recent times may be located in how the appointments to the Election Commission are made. While the ECI is an autonomous institution drawing its powers from the Constitution, the problem lies with the fact that the appointment of the Election Commissioners is done by the government, and that too unilaterally.
All right.
This problem has always been there, but assumes particular significance.
We'll go through it, Prashant.
Thereafter, my Lord, I have just mentioned two things.
We'll go through it. We'll go through it.
I have quoted the directions in that Information Commissioner, and I have said that one disqualification should certainly be there.
Correct.
That the disqualification is that he cannot be at least a member or affiliated to any political party, obviously.
That should be there.
That has to be there.
Yeah. Gopal?
Wait, please. There's a note and a spiral bound volume that I've just handed out.
Yeah.
Lordship will take that.
Yeah.
I'll highlight some portions of that. I just want to immediately just respond to 2 points which were made at the fag end by the solicitor.
Yeah.
Particularly the question that came from Justice Ravi Kumar about the first one was regarding Article 53(3)(b). That has no relevance simply because of Article 73, which he didn't read, and Entry 72, which he didn't read. Because it's very clear that that chapeau is completely different and wholly inapplicable. The second, about the outside presence, a word, a phrase which I find highly objectionable, and he used it thrice. The only outside presence is him. He hasn't been here. He comes suddenly and then he's disappeared again. The outside presence to be used for the Chief Justice of India or for any other authority is not a phrase you can ever employ in the context of supporting and protecting democracy and free and fair elections, which is what this case has always been about. In that, there are no outsiders. There are only insiders.
No outsiders.
So what we have recommended and we have adopted also is perhaps maybe a larger 5-member committee as you have for the Lokpal, which will include the Speaker, which will include the Chief Justice of India, all insiders who will nominate a fifth jurist from the four of them will sit together, and that would be the possible committee. I've given that recommendation. Now, if your lordship will take up this note, I'll try and see how much I can finish, Milord, because I just want point by point. Point one, what we did not argue, I've made it clear. All your lordships have that note, I hope, which
We have that.
we did not argue of mandamus to parliament. We did not argue to
Already
implement.
argued it. Don't repeat.
Yes. Now, the lacuna existence, I want to make 2 or 3 points about. Because I believe that when they made the argument about trigger, which all 3 of them have made, that presupposes the fact that there is a lacuna. Otherwise, we don't have to bother with triggers. It's only once you finish the lacuna stage that you come to trigger. But having said that, here's why there is a lacuna. I don't know if the lordship will have it at easy reach. There is that note that was handed up yesterday with the various provisions of the constitution. That's note 2 that the AG had handed up with the provisions extracted.
Annexure A was
The
there.
annexure A. Now, if your lordship, this requires a little bit of time, so the lordship don't know. Those provisions which are all set out, which employed that phrase,
You have
subject to.
You have mentioned it in the note.
I've mentioned it, your lordship will see the second bullet point in the first page.
So,
But I feel sometimes I need to vocalize this. I mean, we waited patiently while the document is
That's
taking
right.
2 days.
We're
So
saying-
allow me a few minutes.
we give that, we give you. What
Yes.
you want to know, you have detailed it in the note.
I have. There are some points which will supplement this, which I can only tell your lordship.
Before you do all that.
Yes.
Please tell us,
Yes.
is there a lacuna?
Yes,
in-
very much
in
so.
article? You tell us that.
Very much.
That's a frontal issue we have to deal with.
I'm
An issue which you have to frontally deal
I'm
with.
addressing that exactly right now.
Yeah.
I'm telling your lordship that when they use the phrase subject to law made, there are many provisions of the constitution that use that phrase. As far as appointments, services, etc., there are 2 sets of those. Let's ignore all the others which are not relevant. We have to consider posts, offices, services, and the state. That's what we look at.
Correct.
Fall into 2 categories. I've mentioned those articles here.
338 A.
Correct. So 338A, 338, 338B, those 3, along with 324.
Correct.
Those 4 use it in a very special manner, very different from how it's used in 146, 148, 229, and 243K.
Correct.
These are the 8 provisions. There's a finite set in the Constitution which is dealing with services, employment, posts, etc. Now, first, these latter 4, 146, etc., are using it specifically by saying law made
In this
regarding
behalf.
conditions of
In
service.
this behalf.
Yes, and for conditions of service, I'm grateful. In this behalf, specifically with reference to conditions of service. So it doesn't widen it for any other purpose. But if your lordship will just see 338 for a minute, 338. Where the parallel is drawn, 338, 338A, 338B, all use identical phraseology. 338A, your lordships can see, which deals with the scheduled tribes. There's 338A, 2, dealing with the National Commission for Scheduled Tribes. So scheduled caste, scheduled tribes, backward class. Subject to the provisions of any law made in this behalf by Parliament, the commission shall consist of a chairperson, vice chairperson, and 3 other members, and the conditions of service and tenure of office of the chairperson, vice chairperson, and other members who are appointed shall be such as the president may by rule determine. So the entirety of this is subject to the provisions of a law made on this behalf, in this behalf by Parliament. So I'm asking myself a question. If Parliament were to make a law which did not provide for even one scheduled tribe person in that commission, surely that would be struck down. It would be vulnerable at the very least because it is a commission for the scheduled tribes. But the provision nowhere says that you need to have a scheduled tribe person there. I'm drawing the parallel to explain to your lordships that these 3, along with the election commission, falls into a finite set where you have to make a law, which is why we have set out a chart. Just please take up the spiral line linked to this particular issue. We have set out all the constitutional authorities in a table, page 1. The 4 criterion which are necessary: qualification and eligibility, term, removal, and salary. I have given your lordships under this tabular chart, showing your lordships that of all these, where is the lacuna? And the lacuna is in 324, where it's not filled up by a constitutional provision or a statutory provision or a rule. But in every other case, It exists. It's filled up and it's answered. That's point one, limb one of the lacuna argument. I'll just make that good because I need to stitch this up with what I've put here. I'm not going to take an extra minute. I will make 20 points in 20 minutes if I can, but I'll try and keep it as short as possible.
More you can argue because you're saving time.
Yes. I'll continue. No, it's they came.
That's all right. That's all right.
Yes. The second one, that the test that your lordship should apply in examining whether there is a lacuna or not is today, can a law be made under 324 providing for a scheme or a process of appointment? Can that law provide for the qualifications that are necessary for a person to be eligible to be appointed as an election commissioner? If the answer is yes to this, there is a lacuna. I don't have to say anything more. If a law can be made.
See, your concept of lacuna
Yes.
is intertwined with the Attorney General's concept of aspirational law, a utopian law.
It would have been if they had not conducted themselves.
What you're saying is,
yes.
Kindly listen.
Yes.
From 1950 onwards.
Yes.
With the first, that is Sen, Mr.
Yes.
Sen from Bengal.
Yes.
We have had a long line of Central Election Commissioners followed up by Election Commissioners.
Yes.
There is an appointment process in place.
Which we don't know about, but it exists.
There is an appointment process.
You don't.
It's legal
Yes.
also. It is legal till we are not called upon. You have not called upon us to decide the legality of the appointment so far.
No, we are not. There's an appointment
therefore,
practice in place, not a process.
What you're saying.
Yes.
We'll give you an example so that
Yes.
you can understand it better.
Of course.
Supposing the same bench
Yes.
which heard Vishaka
Yes.
was hearing this case also.
Yes.
The question which it poses in paragraph 13, I think.
Yes.
Where it quotes say, in the absence of any law.
Yes.
No, there is no framework, no guideline, no law to give effect to the rights of women being harassed at workplace.
Yes.
So they drew upon international treaties,
Correct.
fundamental right, etc., and they stitched together, as
Yes.
you said, guidelines.
Yes.
Same thing happened in all the earlier cases. There was no law.
Correct.
There was a complete vacuum.
Yes.
Adoption, for
Yes.
example, adoption by foreign
Intercountry
children.
Yes.
There is no law. So they take, this will be what it is. So if the same bench we are hearing it, we are just doing it so that hypothetically.
Yes. No, I'm
we can
absolutely
decide that.
agreed.
The court would come to the conclusion, no, this is not a case where there is a vacuum in that sense. There is perhaps a vacuum in the sense that you are projecting, namely,
Yes.
a lack of an ideal system of appointment. And you're right, because
Yes.
what lot of complaints are there.
Yes.
But to say legally, juridically, that there is
Yes.
no law or there is a vacuum may not be fully correct, because when the use of the word president shall appoint, it brings in a whole gamut of procedures, constitutional system contemplated, like you pointed out correctly, in the Article 73, Council of Ministers, Rules of
Yes.
Business, and they have been making the appointment.
Yes.
You cannot characterize that as illegal. It will become illegal only if a procedure prescribed by law by Parliament is opposed to what we have said. Supposing Parliament also says continue the same thing.
That's
and
No,
put some
absolutely.
flourish.
I'm not
That's-
characterizing it.
Therefore, we have to
Yes.
address that issue.
I'm
Because unless there is a vacuum,
yes.
we cannot say there is a vacuum.
So
There is no vacuum. I mean, supposing
Yes.
there is a vacuum, we can say there is.
I understand. So let me put it like this.
Ah.
The Vishaka bench would be told that, look, what is the principle we are looking at? The fact that women's rights under Article 21 are violated. The principle that the Vishaka bench will be told. The other bench, identical to this one, will be told what is the principle we're trying to protect here. It's democracy and free and fair elections. Democracy, primarily. The essence. Now, you have a principle then before both benches. Before one bench, you're saying there is no law at all. There is not even a scratch of it. You can try and read it into, there would have been arguments at that time saying IPC, some provisions will cover this and that. But that still is not an answer to what the CEDAW convention, which was imported there for those purposes. Correct. Here the argument is that the absence that we are seeing is a very important central aspect. It's not enough to say the president puts a warrant on the appointment, so the law is fully covered. It's not enough. And that's our argument. Our argument is that the minute you don't have anybody but the executive deciding on the individual or set of individuals who are given the solemn charge of this basic principle of upholding democracy by having free and fair elections, minute you don't have independence in that, that is a gaping huge vacuum. The fact that you don't have independence in the appointment process, that's what the vacuum is. We are not saying that everything regarding election commission, it's not like we don't have an election commission. We have an election commission. Nobody's done that. It's not like we didn't have a Supreme Court. We have.
Same thing with police
The-
reforms.
With police reforms, with administrative reform. What are we doing here? We are moving forward with the constitution based on the experience that we have in society and in polity. Those experiences teach us.
That is an area actually largely governed by value judgments.
Yes, of course.
It's relative.
Yes, it will be.
To you,
Yes.
there is a gaping hole.
Yes.
To them, there is a system in place.
Yes.
A system in place which has turned out eminent, perhaps less eminent, competent, very competent.
There may well be.
But relative.
There may well be.
But there have been individuals, and it is not as if without an election commission, the entire machinery which it has, the rules which they have, because when you talk about independence,
Yes.
please remember one thing.
Yes.
Independence is not an unruly horse that a person can ride and say
True.
that I can do whatever I did.
Correct.
Independence partly at least partakes of playing by the rules of the game.
Yes.
Supposing the election commissioner, chief election commissioner is there is a rule, then I will overlook it. That is not independence.
Right.
In areas where he has discretion,
Yes.
he exercises discretion, he shows his independence. Fine.
Yes.
So therefore, if there are, it's not as only with the persona of the chief election commissioner fitting the bill in terms of, independence, which again is cast in absolute term,
Yes.
that everything else will follow. May not be.
No, it won't. It won't. We are not at all assuming that this system will make everything perfect. It won't. There's no question about it.
Oh, you have got that.
No,
We'll give you some more time tomorrow, but try to.
I'm sorry.
You are making submissions tomorrow.
Yes.
Two things.
Yes.
The hammer is on rules to be Parliament has to frame. Suppose we delete it, it would not have been there in the Constitution.
The phrase subject
The
to
phrase.
law. Yes.
Not have been there.
Yes.
Like when you go for appointment of a commission, chairman of a commission, public service commission,
Yes.
there is no such requirement of.
Yes.
Okay.
Yes.
Now also the union government or the state government make appointment of a commission chairman
Correct.
and the members,
Yes.
and there is no requirement of subject to framing of rules.
Correct.
So if this particular phrase, addition
Yes.
of subject to rules being framed by the Parliament,
We're not there in the.
but not there in the Constitution,
Yes.
what will be the
I
situation?
would still make the argument, and I'll make the argument.
So according to you, if
Yes.
that would not have been there,
Yes.
still you will hammer that there is a vacuum?
Yes, I would still argue that.
All right.
I would still
So
argue.
keep it in mind.
Yes.
So we said 20 minutes yesterday, today I've given you extra 10. So we'll give you, sorry for the questioning, we have
No,
to.
I want to respond.
Only one line, my lord.
I want to respond to those questions.
Only one line, if I learn.
Tomorrow by 11 we'll start, and 10:30, 11 by we'll start.
Yes.
Lord, can I
Yes.
can I have only a second?
Treaties, my lord.
If-
Visakha international treaties is there. Here is also international treaties and Indian
There is
aside.
no international treaty.
But can I have 1 minute? When I said outside prison, it was obviously outside the executive. The lordships have understood. Everyone is, my lord, ours, outside the executive. Let it not be
I
misunderstood
have.
by your lordship. You called our chief justice, that is what he said.
That's
One-
not his option.
Small
That's what I
intelligence.
don't have the lordship. I'm not just trying to,
That's all
the
right.
lordships have understood, my point, outside the executive.
We have understood. We have-
Lordships of
Both of us.
the-
we have all-
This intelligence, in case I have to be in the other constitution tomorrow, I hope either the solicitor somebody will be able to answer that other issue
Please produce that.
till the time.
Please,
And then
otherwise.
I've seen the application says the direction that the appointment shall be made by a collegium. That is the direction.
That's right.
Right. Therefore,
so when
if I
you
have to
do that-
take it as an injunction that no
We hope
appointment
you
in
don't-
the meanwhile,
We don't want to be confrontational.
I.
But we hope we'll
it
produce
brings in
a
it brings
file
in an
just for us to peruse it.
Yeah.
If you, there's no danger in permitting us to produce it. We happen to be judges. We happen to be.
I'm only trying to express my, and then
We
finally.
happen to be
signing off.
judges of the court. We are hearing this
No,
matter.
no,
That is
I-
all.
I hope I made myself very clear.
Yeah, but then you will produce it tomorrow.
After this, we'll start.
Yeah. But if after that we start delegate, we'll come in listing up tomorrow.
No, but say
It's
that.
also like.
We have said that. We have said that.
So 10 minutes without participant.
No, whatever is it, by 11 sharp, whatever argument is there, it will be over, it will be reserved, yes. Very good. Great.